All right, thank you so much for joining us. Matt Murphy is with us, our ABC legal analyst, former prosecutor, and homicide prosecutor. So this is an important topic for so many in our area here in the Inland Northwest. We're talking about the changes that we're seeing with the Kohberger trial, how it's moved from Latah County to Ada County, and all of the changes that we expect to see in the coming weeks and months ahead. So thank you, Matt, for being with us today. We appreciate it.
Happy to be here.
So first off, we just found out in the last week that this trial is going to be moved now to August of 2025, which is 3 years almost, nearly 3 years since the murders of the 4 University of Idaho students. So talk to me about, in your experience, how unusual, or is that even unusual, to have a trial moved back that long?
Well, when you're talking about capital case litigation, he's looking at the death penalty. So the name of the game, especially in the Ninth Circuit Court of Appeal, which is what oversees this case, which is the same as California, the name of the game is avoiding appellate issues. So for anybody that's actually done enough of these, essentially that is more than half the battle in any case like this, because the worst thing that can happen from the prosecution standpoint and also the court standpoint is to have a jury go through this, have all these families go through this, only to have the case reversed because of some sort of error. So what that means in reality is it means that the defense essentially gets all the continuances they want in a case like this, because you never want to set a case up for what's known as IAC, or ineffective assistance of counsel, which is one of the most commonly alleged reasons to reverse a capital case. So if it actually goes in August of 2025, believe it or not, in the death penalty world, that is pretty much light speed. I had cases that took a decade to come to trial in the capital case realm. So if they can get it that fast, that's, believe it or not, that's actually very fast for capital case litigation. As far as the transfer to Ada County, again, this is one of those things that the defense brought the motion, and it's an abundance of caution move by the court. By allowing them to do that, they're essentially eliminating issues. I think it was the right call just to ensure the integrity of this conviction. And look, the evidence in this case, in my opinion, is overwhelming against Mr. Kohberger. It is incredibly persuasive. I've presented cell phone evidence like this before, and the DNA evidence that's on that knife sheath is also very compelling. The phone tower pings is very, very persuasive in front of a jury. And I think that the judge sees that, the prosecution sees that. That's why the prosecution didn't really put up too much of a fight when it came to changing the venue, because I think you're going to get a jury very similar to what you would have had in the original venue. And I don't think it doesn't hurt the prosecution case a bit. And I think it's actually smart by the court to do it that way, because it ensures the fewest issues on appeal possible.
Wonderful. Okay, that actually answers a bunch of the questions that I have for you. So it may get a little repetitive here, but I do want to ask and kind of go back to what you just said about having cases that lasted a decade. Would you say then we should expect more delays in this trial?
I wouldn't be at all surprised to see more delays in this trial. It's for your typical just run-of-the-mill murder case in California, not even a death penalty case. And every county is a little bit different, but in Orange County, I mean, our average, maybe for generic run-of-the-mill, nothing to it, like 7-Eleven robbery or domestic violence homicide, it's 3 to 5 years to get those to trial. It's very important that the defense receive all the discovery, that they've had an opportunity to properly investigate. And, in a way, you want to do that. You want to ensure that the rights of the defendant are scrupulously honored so that there's no appellate issues, and just to be fair, and you want to extend the professional courtesy to professional defense lawyers. And that's the way it should work. But when you get into capital case litigation, they receive the highest level of appellate scrutiny. That means they're going to get the longest, hardest, closest look by the courts of appeal. And we want it to be that way, right? And in the state of Idaho, this very well might be an actual death penalty case. In California, there's a moratorium that's been declared by the governor. So nobody's getting executed in California probably ever again. But in Idaho, it might actually happen. So you want to be careful. You want to make sure that it's right, because when you're talking about the ultimate penalty, the integrity of the system kind of demands the most careful step-by-step process that they can provide. And so it makes sense. It takes a while. And it's also very important to remember, look, as a prosecutor, I never really cared if the guy was in custody, sitting in jail versus in prison. Never really mattered to me. They're not going to hurt anybody else. Jails are usually maximum security. So although escapes happen, it's very rare. And if the guy is sitting in a cell in a quote unquote jail, or sitting in a cell in a prison, it doesn't really make that much difference. He's off the street, in my view. And I know the families really want this to go, and they live with the apprehension. And that is a very critical part of any case like this. For me, it was always really, once you get past protecting the constitutional rights of a criminal defendant in a homicide case, the next step for me is always the families of the victims. You want to make it as easy on them as you possibly can. And I know that one of the families didn't want the venue to be moved, but which I understand. We have to be sensitive to that, and really the prosecution should be spending a lot of time talking to them, making sure they understand the process. But the only thing worse, and they haven't been through it before, so they've been thrust into this situation. It's overwhelming, it's complicated. But the only thing worse than the inconvenience of maybe having to drive to another county and get a hotel is a case that gets reversed because the court denies a motion like that. So it's careful steps, methodical steps to ensure the rights of the defendant, but also in the long run, as long as it's upheld on appeal, the family should be, for the temporary inconvenience, they'll benefit in the long run from that.
I'm glad you brought up the families, because in our area, Moscow, Spokane, Coeur d'Alene, the entire inland Northwest, when this happened, really found connections to these four families, whether it be the same summer camp that their kids went to, or the University of Idaho, of course. So many alumni are here in this area. So there are just a lot of personal connections from our viewers who watch and are following this case. What do you make of you said you believe that the state has this case, figured out. What do you make of the gag order in this case? Because from our side, we found very little information from the very beginning. I mean, there's no murder weapon. We have the knife sheath that you talked about, and there's the DNA, but we just don't know a lot of the details that we assume will be coming out in the trial.
That's right, and I think that I'm guessing here, and I haven't read the file, of course, but I think that where this went wrong at the very beginning is there were a bunch of online sleuths who pegged one of the professors at this university as being the killer, right? And I think that the interest in true crime personally is a good thing, at large, like, taken as a whole, the public educating themselves about things like DNA evidence or cell phone pings. I think we benefit as a society from greater education, which the interest in cases like this really is. This is a very topical thing. I think generally we win, and social media generally is a good thing on this. But every once in a while, it goes off the rails, and it did in this case. So you've got some poor professor that had nothing to do with this at all, and you got some sleuths who decided that was him, and now that guy's name, anybody who Googles it, for years and years, I mean, we're presumed innocent in the courtroom, but we are not presumed innocent in the court of social media. So I think that weighed in personally in the judge's decision on that somebody had already been hurt by sort of the rampant speculation. And again, the court's job here is to ensure the integrity of the case. They want to make sure that the rights of Mr. Kohberger are adhered to very carefully, because the court is looking at the big picture. The court doesn't want this getting reversed because of any mistake. Okay, so I think that these judges have been doing a pretty good job of that. My only concern, I wouldn't even call it a criticism, is for the prosecution on this. They've got to, the way the family keeps making statements publicly, or at least one of the families, maybe multiple families of these poor victims, it seems to me like nobody has sat down with them and explained the benefits of, why the change of venue actually doesn't hurt them and why it's actually a good thing. And, I don't know that, but, if I had a family, I did a lot of high profile cases. I worked homicides exclusively for 17 years. None of my families are giving press conferences, when, a hearing didn't go our way or there was a continuance granted by the defense, because my bereaved family members all understood the process. And, I that's my only question here is, has somebody actually sat down with them and walked them through the complex, ins and outs of the criminal justice system, especially in capital case litigation, because you're guaranteed to get a change of any motion in a case like this. I mean, I was kind of surprised that they granted it, honestly, but I understand exactly why they did. I think it would have withstood appeal had it been denied, but these judges are doing everything they can to ensure the integrity of this case, especially if he's convicted, and I think he's going to be convicted. I mean, this evidence is really powerful stuff. And of course, you're right. There's also a bunch of stuff we don't know. They got into his computer. I guarantee there is evidence that we do not know about that was recovered from Mr. Kohberger's computer or cell phones. Guaranteed, because there always is. And we haven't heard about that yet. So this isn't just about the phone pings, the video of the car, and the DNA on the knife sheet. There's going to be more to it than that. And you're right, we don't know what it is yet, but that's the court and the prosecution trying to be very careful to ensure the integrity of the conviction.
And our next hearing is in November, and that's going to be motions that are from the state, arguments about the death penalty, because the defense is trying to remove the death penalty. What do you expect us to hear in that hearing?
Yeah, look, the defense, one of the biggest challenges on appeal, again, is that IAC thing. And what happens is the appellate lawyers who get involved in a case like this have no allegiance to the trial lawyers. So they will immediately begin throwing them under the bus. They will accuse the court of judicial error, they'll accuse the prosecution of misconduct, and they'll accuse the defense of whatever they think the defense didn't do. And so it's kind of, it's a pretty ruthless and mercenary period of armchair quarterbacking every decision they made. Okay, so on one hand, the defense has to bring every motion imaginable in order to, again, to cover themselves, essentially. And what that means is we're going to see a bunch of motions that essentially are nonsense. And we've seen some of those in this case already. We saw this, hey, Judge, you have to interpret the Idaho statute concerning capital case litigation as non-existent because of the original charter for the state of Idaho. And that was interesting. It was novel. The problem is that if you research that, which I did, that issue has been raised over and over again, and it's consistently been shot down by the courts and by the courts of appeal in the state of Idaho. So that sounded very dramatic when we read about it, but that was going nowhere from the word go. And I think that what we can expect to see in November is exactly the same thing.
And I think it's important for people in our community also to understand, you have prosecuted many homicide cases, high profile. This is what was at one time an internationally known case. So this is kind of the largest stage that you get to. We are going to start to see, it looks like in the next year, the questionnaires for the jury go out, and we don't ever get to see those. But you have a better idea of what are some of the questions that are asked of these potential jurors to ensure that this is a fair trial.
Yeah, just to kind of flow with what you just said, I was the Orange County prosecutor on the Golden State Killer. I did Rodney Alcala, the dating game killer. I had, Skylar De Leon, who murdered Tom and Jackie Hawks on their yacht. I have been in and around capital case litigation for my entire career in one form or another, and I've been doing this for 32 years at this point. So what we're going to see in those questionnaires is the prosecution, and this is another thing that nobody seems to know, they are entitled to what is known as a death qualified jury. Okay, so what that means is this isn't just, we're going to get random people from the community and hope for the best. Um, they have to weed out people that are either religiously or politically or ideologically opposed to being able to follow the law. And the law of the state of Idaho says that the jury has the option of imposing the death penalty. So it's a gigantic waste of time if you put people on there that can't vote for death. And essentially, what the jury will be tasked with doing is in California, they're called A through K factors, but it's essentially their job will be to weigh and consider the aggravating versus mitigating circumstances. So first, it's a bifurcated process. Okay, so what that means is first the question is, did he do it? Is Mr. Kohberger the actual killer? Okay, and the jury is going to convict him of that, is my prediction. Then the next part, perhaps arguably the most important part, is now that we know that he's the person who did it, the jury has to consider what are the aggravating factors, including victim impact, which means the family members of these poor kids that were slaughtered in that house will get to take the stand and talk about the impact it had on their lives. And then in California, it's called B factor, other crimes of violence, which Kohberger doesn't have. But then they'll consider like any points of mitigation. Was he abused as a kid, which he wasn't? Was he under the influence of drugs at the time, which it doesn't appear that he was. So they'll weigh all of these different things under the law, they'll weigh and consider, and if the aggravating factors substantially outweigh the mitigating factors, you need a jury that is capable of imposing the death sentence. If based on balance, they have to be able to vote for it, just like they have to be able to vote for life without possibility of parole, which is option 2. Okay, so it's like one option is death, one option is life without possibility of parole. They have to be equally open to both. And so what the jury questionnaires are designed to do is vet out people that either couldn't vote for life without possibility of parole. In other words, they're too emotionally caught up in the idea of somebody that would slaughter these 4 innocent kids that they could never open their mind to the idea that there might be mitigating evidence that may, in balance, speak to something less than the death penalty. And likewise, the people are entitled to, or the prosecution is entitled to, a group of people who objectively, in a sober way, going through that law and going through the aggravating factors, if they decide that it substantially outweighs any factors of mitigation, they have to be able to have a group of people that could impose the death penalty. Okay, so that's the way it works. So the questionnaires, and I've read more of these in some parallel universe, I'm still reading them from my last capital case that I did. It'll be about a 20-page questionnaire on, can you impose the death penalty? Do you have any religious beliefs, ideological beliefs, political beliefs that would prevent you from being fair? What sort of news stations do you watch? Where do you get your information from? Do you belong to any organizations that advocate for or against the death penalty? And each side is entitled to that. Kohberger himself is entitled to people that have to be open-minded to life without possibility of parole. The people and those victims' families are entitled to a group of people who can impose the death penalty. And that's the way it's supposed to work. And that's why, I'm pretty nonplussed about Ada County. I would love to have, Idaho juries. You're not going to get anybody. Yeah, I mean, you're entitled to people who can impose the death penalty. Whatever county you wind up in the state of Idaho, you're going to be able to find 12 people who are going to be fair. And that's what Kohberger is entitled to. That's also what the victims are entitled to. And they're going to find that. And whether that's in, the upcoming August, and hopefully it will go that soon, or whether that's the following year, or whenever that's going to be, they're going to find that fair jury. The judge, hopefully, so far they've done a good job of this, in my view, of ensuring that, the defense is given what they need to properly prepare, and then they will fairly preside. The jury will assess this evidence. They will convict him of this, I believe, and then they'll decide whether or not it's worthy of capital punishment. For what it's worth, I sat on our capital case committee for 15 years. I reviewed a lot of cases. We only sought death in less than 4% of the cases that qualified for death. Most murders aren't even special circumstance murders. So the vast majority of murders don't qualify in the first place. Of those that do, we would seek it only in the rarest case. And this case would have, I think, satisfied everybody on our committee that this merited pursuing the death penalty. I mean, it's that vicious, it's that gratuitous, it's that unnecessary. These kids with that innocence is that horrific, and the evidence, in my view, is that overwhelming.
And I have about 7 or 8 more questions that I'd love to ask you, but we don't have enough time. I do want to ask you about, no, I could just talk to you all day, but I do want to ask you about your book, because you have written a book, and I think, like we mentioned at the beginning, there's a lot of true crime enthusiasts that are following this case. Yeah, and they may be interested to hear, just your perspective.
Yeah, you mean about the book?
Well, why did you write the book, and what can they find in the book?
So it might be a little twisted, but I wrote the book because after 17 years in that unit and 26 as a prosecutor, I missed it so much that I missed my team, I missed my crime scenes. The way it works in Orange County is we would actually go to our own crime scenes. So most places don't do it that way. Most of the time, the police investigate. One DA reviews it for filing, another does the pretrial, another does the prelim, and somebody else tries it. In Orange County, you show up yourself. So you're assigned patches of the county. I had Newport Beach, Costa Mesa, Laguna, and Irvine. So any murder that happened in one of those cities for 17 years was automatically mine. I'd roll out my investigator in the middle of the night and start before the body was moved of the poor homicide victim, and with detectives, figure it out every step of the way. And I learned so much in that unit, and there's so many fascinating stories to tell. And I decided that it was worth sharing. I pitched it to Disney. They liked it. And yeah, I wrote this thing. So it came out a couple weeks ago. It's called The Book of Murder. And essentially, I walked the reader through my career in homicide, from my first homicide to my very last trial. And I go through the legal concepts. What is a death penalty? How does DNA really work? And I also go through about a dozen of my more high profile and interesting cases, in chronological order, kind of a taxonomy. I do a gang murder. I talk about that. And I get into, the abuse of a child, the kidnapping, and Samantha Runyon, and all the way up through Tom and Jackie Hawks, and then finishing with my Hussein Nairi case, which is about to be a 3-part series on Hulu. And that's a fascinating case too. So it's doing pretty well. I think people are liking it, which the Audible is doing particularly well, which is a mystery to me because I cannot stand the sound of my own voice. But people seem to really be embracing the book, which is humbling and gratifying all at the same time.